What's up, co-counsels? I apologize about last night, okay? I was under. I couldn't be here. Anyways, let us jump into Karen Reed. Karen Reed trial is going to this retrial, it's going to drive me crazy because at this juncture, it is spinning probably, I don't know, it's cartwheels, it's handstands, it's everything. This trial is pretty much fixing to be more dramatic than the YSL trial. Okay, that's where we are right now. Cause what's up, Brooklyn? When I got up here, my expectation was basically to jump into the hearing from yesterday. But it turns out that they have breaking news today, and a former juror or alternate juror is now joining the defense team. This is unheard of. Like, this is unheard of. And what's up, Benji? And if this information is accurate, this juror has zero. Apparently, the former juror is an attorney. Okay, it was an alternate juror, is an attorney, but this person has zero experience with criminal courts. So I don't exactly know what their purpose would be. If it's for jury consultation, there are actual experts. Okay, unless they cannot afford, maybe they cannot afford a juror consultant, right? But there are people whose jobs are to basically, uh, suss out potential jurors. Anyways, I guess Brooklyn is loving this. I just want a normal trial. Maybe I should have moved on to something else because this trial is not normal. I could have gone. What's the case? There's a case out of California. That trial has been going on since forever. The socialite trial or Sementali or something. That trial, Nicole, is that her name? I don't know if that's her name or not. But that trial has been going on forever. I probably should have watched the roommate trial because it turns out there was an unexpected verdict today. Those are my type of trials. I just want a normal trial. But Karen Reed is spinning. She's doing all types of things. Anyways, let's get into it. We're gonna watch some. We're watching clips. Okay, let's get into clips because I don't have 2 hours.
Your Honor asked for a proffer from the defense regarding third-party culprit.
I don't know. Let's just go to the whole thing. I'm sorry, you guys. I'm a little nosy. Yeah, this lady or the love affair, I said socialite. This Monica, I called her something else. I think I called it Simone, Nicole. This trial has been going on forever. This is the trial I probably should have been watching. It looks like a normal trial. Okay. I've watched here and there, but not extensively. Anyways, where's Karen Reed? Where is Karen Reed? Karen Reed, Law and Crime. Yeah, that's weird. Why didn't this? Oh, because it's a different law and crime. Got it. All right. Hold on, though. You guys know I'm distracted. Let's see if they have.
They're gonna probably be arrested.
I don't know what he is going on. See if they have other clips. What's going on here? I'm getting I'm parenting, you guys. Sorry. I'm parenting. Apparently life insurance hairdresser. All right, let's move on here. I was trying to see if they have clips. There's this guy. I actually wanted to cover this case before it was even on Law and Crime because I saw the news. It's just, I don't know. We'll get into it. I cannot find what I'm looking for. All right, let's just go to the live stream from a day ago. Yeah, but this case is, they're all over the place. It makes my head spin. I hate this audio.
So, thank you. So, similarly, regarding the third-party culprit argument the other day, Ms. Yanegi, I see you did file something late yesterday, so I got that. I'm just wondering if either.
Okay, before we really get into the thickets of this, the one thing that I know about yesterday's proceedings was basically Judge Canoni shutting the prosecution down as far, they were trying to get privileged communications. Okay, that is, I don't want to say it's unheard of, but I would have been very surprised. I would have been very surprised if she allowed the prosecution to proceed, or if she ruled in favor of the prosecution. That would have been very, very surprising.
The Commonwealth or the defendant want to be heard on that.
The Commonwealth does.
Okay, so I'll hear you, Mr. Brennan.
Your Honor asks for a proffer from the defense regarding third-party culprit. Alternatively, evidence that would be separate regarding third-party culprit aspect of Bowden. We received some information from the defense that does not distinguish
1220.
whether their intention is that it applies
What are you talking about, Brooklyn?
to third-party culprit or whether it applies
Oh, I see. I see what you're saying. Let's let her. I'll let him talk for a little bit.
to a third-party culprit aspect of Bowden.
We'll get
Those
into it,
concepts
though.
are logically and legally distinct. Regardless, when you look at the proffer by the defense, it is insufficient and inadequate for both third-party culprit and for any third-party culprit aspect of Bowden. Two different analyses, but the evidence is equally feeble for both.
Okay.
Relative
Where's
to
all
third-party
that?
culprit evidence, there are a number of cases that I know Your Honor is aware of that guide the standard of third-party culprit evidence. Not to iterate the law because it is clear, but there must be relevance, there must be a substantial nexus between the claims of the defense and the third-party culprit theory. They provided us 3 people that they identify as third-party
1107.
It's helpful.
Oh, so you're talking about actual time over here as opposed to timestamp? I thought you were talking about timestamp. Let's get into it a little bit because I was pretty much interested in the third party culprit issue. But that's an hour later. Let's just jump ahead. Okay. We'll listen to Brooklyn because Brooklyn's Brooklyn's running the show. So let's find 12. I want to see what's happening here though. You guys know I don't know that I have ADHD, but I probably have something. All right. I know people with real people that have been diagnosed with ADHD are probably like, okay, what is she talking about?
A case where they said, well, that should be in addition to what
Inside, behind the scenes.
any questions I would just.
All right, we'll take it from there.
Thank you very much. So let's go on to.
This audio's awful.
The Commonwealth motion for production of records regarding.
I was watching Judge McBurney again today. Okay, you guys know that's my favorite YouTube judge. The trial is taking shape, but as I've said before, if the Weissel trial did not highlight enough incompetence of the workings of just systems in Georgia overall, this Jai Williams or State of Georgia v. Jai Williams case, very concerning in terms of how they handle I'm not going to say the word, our kids. Okay. Very, very concerning.
Unsolved productions.
Okay, are you talking? I'm stressed out. I know these people are stressed out from their jobs.
Yeah.
Yes.
Your Honor, the Commonwealth filed a Rule 17 motion for records from unsolved productions. It has been discussed briefly in court at times during argument. There was a so-called documentary that was aired in a 5-part series. It gave a inside, behind-the-scenes look of the defense team and Ms. Reed as it prepared for the last trial. This 5-part docuseries produces a number of statements from the defendant.
Regardless, I'm still baffled by the defendant's choice to have Karen Reed out there, in essence, really testifying. I'm baffled by that decision. That decision. Look at goddamn Turtle Boy. Look at Mr. Turtle Boy himself.
Many of them extraordinarily.
Anyways, I'm baffled by their decision to allow their client to be interviewed while a second trial is pending. It just doesn't make sense to me.
Some of them, from the Commonwealth's perspective, extraordinarily incriminating, and many of them inconsistent with statements made publicly in the past, including Dateline 2020 into Gretchen Voss. We serve the
Play the clips, but you cannot get
service in Boston.
You cannot get that
The
attorney-client
record is the producer
communications
of the
privilege,
series,
attorney-client communications.
and they have been notified. If the court allows this motion, I expect they will provide the information to us by the end of the week. I understand there is probably over 200 hours of recorded interviews, and we expect to use a number of those statements at trial. They are statements of the defendant, they're admissible substantively, they're admissible as admissions, and they're admissible to show contradictions with other statements.
Okay.
And so they are material and relevant. I understand the time frame. We haven't had the privilege of seeing them. The defense was there for a part or most of it, but we will use the time we can to sift through it. We're not looking for a continuance or additional time to look at the materials. We'll look at them as we prepare for trial. And so I'm asking you to grant this. It clearly makes the Rule 17 standard material relevant. We don't have access to these before trial. We won't be able to prepare for them if we get them pursuant to a trial subpoena. They've been properly subpoenaed and they're forthcoming.
Where am I? Oh, I'm way behind. I was like, wait, okay, 12:09, but this is a good point.
Is no one here from Unsolved Productions opposing this?
There is
What's her name, Bev? Speak up.
not.
Is no one here from Unsolved Productions opposing this?
There is not.
Defense want to be heard at all?
Where's my guy? Why is my guy not talking?
We're aware of the communications back and forth between the Commonwealth and the production company. So we've not been privy to that. This is the first that we're hearing of any communications that they've had with the production company. I think obviously in an abundance of caution, they should be given an opportunity to oppose if they wish. Nothing officially been filed one way or the other. So we're not in a position to argue on their behalf, for sure.
All right. So, we have two things left to discuss. I want to talk about jury empowerment. We also have a
Needs to
Commonwealth
speak up.
motion regarding Mr. Yanetti's. Mr. Yannetti, it's 12:10. Which one do you want to?
Okay.
On first? Do you want to talk about the impoundment, or do you want this motion?
I'm not going to leave with those.
Tomorrow, as in Thursday, Brooklyn?
Do you have a preference with some for lunch? All right, so let's do that motion. Commonwealth's motion to compel communications between the defendant and attorney. Still looking at the
You are so unclear. The Commonwealth is not seeking all communications between Ms. Reed and Mr. Yannetti.
Okay.
We're only requesting the communications that may be on any type of records in the possession of the Commonwealth. And specifically, there are phone records which have been redacted, and I do not know what is underneath those redactions. And we believe we have an entitlement to the information in the narrow area where Ms. Reed has waived her attorney-client privilege. Specifically, where the defendant intentionally divulged the content of her communications with Attorney Yannetti about liability and potentially striking John O'Keefe with her car. Those subject areas in that narrow time frame are no longer privileged because they're now public. The Commonwealth has identified a very narrow window, and that's a 3-day period, and that is what is mentioned by Ms. Reed in her public statements, that she spoke to Mr. Yannetti and she thought about it for 3 days.
Mm.
We're not looking for any information beyond what has been waived. We're not looking for any information on collateral issues, and that's why we suggest that the court look at those records in camera, and the court makes the assessment whether or not the area in which where Ms. Reed waived her attorney-client privilege, whether any of those materials would similarly be waived because they are.
Oh, I
exactly
see. I thought you were talking about my guy Alessi. Okay. So Brooklyn says I watched it a little bit before the end. Whether he wants to take the stand tomorrow morning. Uh, Listen, in that Jai Williams case again, I've made it clear I'm disappointed in the questions that the attorneys were asking because, from my point of view, the jurors were asking better questions, more pointed questions. Not to say that the attorneys did not do anything at all, which they did. Um, as far as the defense attorneys in that case, I do question a lot of their cross examination, because the cross examination, unless of course, because I heard towards the very end today, they will communicate, or at least the prosecution relayed to the court that when they were talking about this jail phone call, whether it should come in or it should stay out. Apparently, when the defendant was talking to his mother, the prosecution pretty much said that uh, the defendant is alleging that GBI planted his DNA or something along those lines. Um, I still, I think that the defense should have asked better questions in that case. They should have asked questions that pretty much would drive home whatever their theory is. Uh, and if the defendant does take the stand, okay, if the defendant does take the stand, I don't know exactly how, unless the argue or unless the defense theory is that his DNA was planted, because apparently there was something along the lines of the a seal being broken, something along those lines. But then again, the independent folks or the witnesses, they said there was nothing wrong with the sample. Unless that's all they're arguing, I do not know that defendant, I do not know that Jai Williams gets up there and says, no, we had consensual, with consensual intercourse or whatever. Because if he admits to that, then he's he's definitely going down. Uh, it's hard to explain. It is hard to explain how his semen is deposited in, an R victims or an alleged R victims reproductive organs. I don't know how they explain that away, but I think that my opinion, the defense should have done better with their cross examination. Because I mean, there were at least 2 or 3 witnesses that they just did not cross examine at all. Anyways, let's get back into Karen Reed.
This is made in good faith. Anything that is non-privileged is open to the public. It's not confidential. There are 2 communications that Ms. Reed made publicly that we assert waived the attorney-client privilege as it relates to that issue. Ms. Reed had an interview with Gretchen Voss on June 20th, 2023, and the transcript is page
Ms. Reed
105.
did what?
line
Hold on.
Gretchen Voss. Ms. Reed had an interview with Gretchen Voss on June 20th, 2023, and the transcript is page 105, line 23.
Okay.
She was asked the question by Ms. Voss, you never said, did I hit him? I hit him. And the answer by Ms. Reed was, I said, did I hit him? Question mark. And then, when I talked to David, now this is later, David said, Karen, if you incapacitated him in any way, there's culpability there. And I thought, all right, maybe this is maybe I said to my mother, just to go forward for a second, they were asking me, what was it like? Did they come out? What was the house like? Similarly, in the documentary series, Ms. Reed is video and audio taped, and it was presented on television, that she said, and then when I hired David Yannetti, I asked him those questions the night of January 29th, like, David, what if, I don't know, what if I ran his foot over, or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability. So that's how I thought about it for about 3 days. And so that is where I get the time period regarding these relevant statements, admissions by the defendant about her state of mind and her.
Okay, Brennan, going a little too far. The reason I say that is because, in theory, okay, when I was a public defender, I was never interested in whether the people I represented, in fact, engaged in the conduct or accused of, because it didn't matter to me. So, under those circumstances, in theory, a defendant could, in fact, admit to their attorney that they engage in the conduct that they're accused of. And that's not information that will be brought in, because while, the defendant enjoys, what is this, the privilege against self-incrimination, them admitting to engaging in criminal conduct to an individual that actually lawfully represents them is not information that is discoverable. So I don't know what Brandon was thinking, but Brandon is out for blood, okay? He's out for something.
John O'Keefe in her vehicle.
Well, let me rephrase that. He's taking his job very seriously.
Made during conversations that are obviously no longer protected or private or privileged. They're no longer confidential because they've been intentionally disseminated to the public. And so the defendant has.
Well, why don't you just use those clips or the text or whatever it is?
In this subject area in that time period. And the key, Your Honor, is that it is the defendant herself who made the communications confidential. Even if it was inadvertent or overheard, it would still waive the privilege. This is entirely different. There can be no doubt that there was an intention to pierce that attorney-client privilege for whatever benefit the defense thought it gained them.
Let's think about that a little. Okay, I'm going to play this. Let me think about it. Let me give it more thought.
If this was intentional, it wasn't secretive, it wasn't overheard, it was a exact.
Yeah, I'm still going to stand by my point, because I was thinking about the context. I've given this example before of, an attorney meeting with a client in a McDonald's or some other, crowded place, and openly having a discussion about, a legal matter or the charges or their criminal case, right? Under those circumstances, certainly case law dictates that there was no expectation of privacy as far as the communications between the attorney and the client. But even under those circumstances, I believe the proper channel would be for the prosecutor to pretty much get testimony from another patron, as opposed to asking a defense attorney or asking a criminal. They cannot do that. Asking either the defense attorney or the criminal defendant, or asking the judge to compel those parties to turn the evidence over. So that's where he's failing. What he needs to do is go find the patron at McDonald's that's willing to talk.
And purposeful engagement. So we ask you to review the cell phone extraction, any text and emails that may be on those extractions.
All right, Benji. I'm glad you like your job. Okay. Yeah, I'm glad you are. If anybody has sent me emails these past 2 days, I'm sorry. I rarely open this laptop unless I am live streaming. So, but I'm glad you're good, Benji.
And relative to that short window, relative to this specific area, anything that is waived that is no longer confidential, we believe we're entitled to. It's obviously would be relevant if it's narrowly related to these statements, and we would use that at trial. Thank you.
Okay.
Who's arguing this one?
I am, Your Honor.
Ooh, my God. My God. All right, come on.
May it please the court.
Okay.
The Commonwealth concedes throughout its motion, as it must, that the communications it seeks to intrude into are privileged communications
Right.
between Ms. Reed and her attorney, Mr. Yannetti. 2 of the 3 instances of the communication they cite to are over 9 months old. And that's in 5 months old respectively. So you have 9 months ago, the Gretchen Voss statements, and 5 months ago, the Vanity Fair statements.
Okay.
But they waited until less than 2 weeks before the start of the trial to bring this momentous and potentially far-reaching and consequential motion. Why?
Maybe they
The
just thought of it.
courts are clear that they take an extraordinarily dim view of parties waiting until moments before trial to raise significant issues like privileged communications this close to trial.
Okay.
The Commonwealth does not explain their delay in raising this issue this close to trial. With regard to the third communication, the HBO Max one, it regards the same event that is discussed in the first 2. There is no addition of an event in the third one. So that third discussion, the docuseries, regards the same events that have been extant in the first 2 that have been extant for 9 months and 5 months. The depth of this attempted intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth, because they're either actual or potential clients of lawyers, and it should unsettle every criminal defense attorney in this Commonwealth, and I would dare to say it probably does. As we know, texts,
I like the way Yannetti argues.
emails, and written communications, exactly what the Commonwealth is seeking here, between an attorney and their client,
Right.
are canonical examples of privileged material.
Right.
So what is at stake in this motion? What is at stake is the sacrosanct attorney-client privilege. In Upjohn versus United States, the really bedrock attorney-client case from the U.S. Supreme Court, it established that dating at least from the age of Shakespeare, the attorney-client privilege.
This is what I like about listening to what's his name again? I forgot. I'm drawing a blank. Listening to Alessi and Brennan, they have I don't know, they have a way about them, but they always have these one-liners that are, I don't know, they just stand out. It's kind of like listening to Judge Judy a little bit.
Oldest,
Even though Judge Judy is a judge, but she's a little questionable as far as her decisions are concerned.
privilege for confidential communications known to the common law. And this Commonwealth has identified that it is one of the most important, and it's been recognized in the Commonwealth as early as 1831. And in the context of criminal circumstances, the privilege has constitutional dimensions, as well as it affects the interests of justice analysis that is documented in the Commonwealth v. Goldman case, 395 Mass. at 5:02. And it bears underscoring the basis and the depth of the intrusion is a quote from the very case and the only case that the Commonwealth cites in its motion. It cites one case in its motion for all of its propositions, just one. Matter of a John Doe grand jury investigation, 408 Mass 480. In the case at 485 states, as we have indicated, extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters. A rule that would permit or require an attorney to disclose information given to him or her by a client in confidence, even though such disclosure might be limited to the period after the client's death, would in many instances, we fear, so deter the client from telling all as to seriously impair the attorney's ability to function effectively. We think that the potential is inconsistent with the traditional value our society has assigned. Here's a key point. In the interests of justice, and that's the rooting of the interest of justice analysis, to the right to counsel and to an effective attorney-client relationship. Therefore, except where mandated by constitutional considerations, and it cites C. Commonwealth v. Goldman, Super 395 Mass at 502, which are not a factor in this case, nor are they a factor in our, not a factor in that case, we conclude that the attorney-client privilege should not yield either before or after the client's death to society's interest as legitimate as we recognize that interest in obtaining every man's evidence. So the case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you.
Why is she stopping? Has she made up her mind?
I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for the matter, so the motion is denied.
Okay.
Thank you, Your Honor.
All right. That was quick. All right, Brennan, are you moving on? What's
We
happening?
need to talk about impoundment. The parties need 5 minutes.
All right, so the court, please.
Dang, it's as if everybody has lost momentum. They don't know how to act. Okay. He's telling him, "Good job." That's why we hired you. I like Alessi. Okay. To me, he is very persuasive and he's thorough. All right, let's move on. Yeah, that was the right decision. All right, put it there. All right, some more information. Hold on, while we're waiting for Bev. Did I close? Okay, so about this new juror attorney. Okay, so this individual's name is Victoria George. Okay, so she's the latest attorney to join the team, and she's a civil attorney. You guys know how I feel about civil attorneys trying to do criminal work. I'm not saying that a civil attorney cannot eventually acquire the necessary skills to either be a defense attorney or a prosecutor. It's possible, but you don't start off with a murder trial. That's just not how I don't care how long you practice. You just do not start off that way because you don't know what the hell you're doing. And we've seen this actually, we've seen it play out in real courtrooms. Okay, so she is a civil attorney, and she's out of Massachusetts. Apparently, the reasoning why she likely will be let on or be allowed to participate in this case is because she is already licensed in Massachusetts. Okay. So apparently, unlike some New York lawyers that were trying to join a firm and I guess get pro hac vice admission, she's already licensed out there. I still, I, I'm interested in knowing the value that she's going to add to this defense team. She's talking about, because they quoted her here, was somebody talking about, injustice, this and that, which is fair. I just do not know the value she's adding to this trial, unless she is hoping for, what is this? Unless she's hoping for an acquittal or another hung jury in order for her to get her name out here. I just, if it's for publicity, I suppose, if she's trying to advance her career, I guess I kind of understand it. I still don't get it, but there are a million ways of trying criminal cases. I don't know. There's a lot going on.
The proposed supplemental questionnaire.
Yeah, that does not matter to me. She was an alternate juror, but I still do not know. And the fact that she was an alternate, did not deliberate, that leads me to question the value that she's adding to this case even more. Because what information does she have? With the exception of, there's the young man that was interviewed by Turtle Boy. Okay, with him, if he was part of the Karen Reed trial or whatever, or if he's just talking in the media, I suppose it makes sense because he can actually have discussions and even pointers as to which way the jurors were leaning and why, right? But for somebody that did not even deliberate, what value are you adding? That's what I'm hung up on.
Very similar. Um, so I have a question. So the Commonwealth on your number 5 on the first page. I don't like the 2 questions in a row, 4 and 5. I don't think we need 5. Is that okay with you, Mr. Burnett? I don't think we need both.
Needs to be done.
So that's out. So I'll go through, actually, I'd like to go through the first page of each. The first page of the defendants, number 13. Do you believe law enforcement officers are generally fair and accurate in their investigations? Who's arguing this for the defense?
I can argue it.
All right, so I don't have a problem with that, but it makes sense that we put it after 8. Those series.
What are they
of
talking
questions.
about?
Commonwealth's number 7, difficult for you to be fair and impartial in this case. I don't have a problem with that question, but it would make it difficult for
Okay.
you to be fair and impartial in this case.
Have
A
relationship
jury
with that.
questions. Let's get back here.
What's relevant is there's nothing general. They took the time that this alleged collision occurred. And so in that absence of evidence, it's not even feasible. Colin Albert should not be brought to the stand, attacked with acts that didn't occur, that otherwise would have no admissibility. Really, it seems to be a backdoor way to tarnish his reputation and then bind him with other people the defense would like to attack, to make a general suggestion that somehow this group of people are bad people. I know at the last trial, there was pictures of Colin Albert's knuckles that were scraped. And
Oh my
actually-
goodness, it gets worse. So apparently, this Victoria George attorney, she graduated from law school 5 years ago. 5 years ago. So again, I do not know. I just didn't. I'm puzzled as to the value that she's going to add to this case. I don't see it. I don't see it. Mm.
it turns out that picture, and I think the exhibits were introduced at trial, was taken much later. Pictures taken before that point show that Colin Albert's knuckles on the 9th and 11th of February weren't scraped at all. So because he had scraped knuckles subsequently, because he may have done a video that some use would maybe do and threaten somebody else, not John O'Keefe, has nothing to do with this case whatsoever. It's an attempt to introduce alleged aggression or prior bad acts, but there's no bind whatsoever. The second person that the defense would like to identify as a third-party culprit is Brian Albert.
Okay.
And this is some of the gross generalizations that you see with Colin Albert. No specificity, but trying to assault his general character by generally suggesting things that may or may not be accurate in just telling part of the story. They claim he didn't have a good reputation among fellow police officers. No evidence. They claim it. And even if it was so, has nothing to do with this case. Known as a bully. So rumor clearly is not admissible in a criminal case. Had a history of sucker punching officers. We don't see any specificity. We don't see any evidence. We don't see any information. We just see a general attempt at a character assassination to portray him as somebody who is either capable or a bully. Nothing relative to John O'Keefe. Nothing. They suggest, and I'm not sure what the basis for this is, that he was drinking heavily that day when he went to a funeral with Mr. Higgins and another person. It is true that he was at the hillside around 9 o'clock and was drinking around 9 o'clock. So all of this information is just...
I know in one of these Karen Reed live streams, somebody commented that this case has pretty much motivated them to give up drinking.
No inflammatory accusations about character. They say he was a trained boxer because when he worked out, he boxed and he was engaged in charity events, some dating back to 2003. By that standard, anybody in the neighborhood who has any self-defense training, mixed martial arts, or boxer would be on the target list. The fact that he is a police officer and that he is physically fit and that he trained to protect himself doesn't make him a third-party culprit. It is this general suggestion of strength and distorted into a hopefully perceived sense of violence that it has no root at all, no root. They went as far to say he was investigated by BPD for violent conduct, but they don't give any details. If they looked, they could go online, they could investigate potentially. There is no sustained findings that are known to the Commonwealth against Brian Albert in internal affairs, none whatsoever, ever. And so to make the suggestion he was investigated by BPD for violent conduct, they provide no fact.
Brooklyn says,
Even though
did you see the funny hearing today? And she ran off with Nathan in the airport. That's wild. Really? No, I read some of the headlines. Apparently, the Senate tore into her, but I did not actually watch the hearing. I need to go find Funny and Nathan.
it is off base.
I'm trying to stay away from Fulton County with the exception of Judge McBurney. And I mean that courtroom I just watch for my own pleasure. But I'm trying to move on to better things, okay?
Entirely. It has nothing to do with John O'Keefe. They're trying to suggest that he has a propensity for violence. And they don't do it very well because they provide no details. These are all just general accusations by the defense. In fact, I would say it's not important or admissible. You can't bolster the good character of a witness, but to simply make suggestions of bad character is not any root or tethering to this case specifically. Instead of bad character, Brian Albert was a two-time recipient of the George Hanner Award, has many, many medals of honor from the Boston Police Department, but that is not the issue. They suggest that he was involved. So they know that they have to tie him not only to the scene, but somehow to Mr. O'Keefe. And other than being at the bar that night and Mr. O'Keefe and Miss Reed pulling in front of his property that night, there is no association between the two. They say he's present at the scene of death. by all evidence, Mr. O'Keefe died feet from the street near the flagpole in front of 34 Fairview. So that's a little bit broad. He wasn't present at the scene of the death. He wasn't there. That happened out front on the front yard near the flagpole, about 70 feet from his house. The body was found feet from his front door, arguably, okay, 70 feet, 75 feet. He admits to being home. He doesn't have to admit he was home. Now, here is another claim without any evidence whatsoever. The defense states emphatically, computer forensic data overwhelmingly establishes O'Keefe entered Albert's house. I haven't seen that evidence. Based on what? So if they're going to make an offer of proof to the court and they're going to make claims to substantiate this theory, they have to have proof of it. And in their motion, I see no proof whatsoever that overwhelmingly establishes John O'Keefe went into the Albert house. In fact, what we see is the opposite.
Okay.
In the past trial,
How much
numerous
before
people
defense
every
responds?
single person. That was
I know. Brooklyn, Benji, what did you guys make of the hearing if you actually watched?
stated they did not see John O'Keefe enter that home. Every single person. Now, whether you believe it or not is irrelevant. What's relevant is there's nothing to the opposite. There's an absence of evidence to the opposite. In fact, the phone data and the Waze data and the GPS and all the data puts John O'Keefe at the front yard, not in the house. So if they're asking the court to make a finding of substantial link and substantial proof that John O'Keefe was in the house, they have to actually give you the facts and the science and the data to support that. And I don't expect that will happen. They add that there was going to be expert testimony that the scratch on John O'Keefe's arm was from an animal
What day is it today?
or a large dog. And because Brian Albert had a dog in the
26?
house, there was some type of inference. Dr. Russell has already testified at the Lanigan hearing that she's not saying that those bite marks were from Chloe. Although it has not been decided by the court, Dr. Crosby has done molds that show that the teeth comparison is totally an opposite. And so even the defense is not saying, as I see from the disclosures, that Chloe bit John O'Keefe. Their version, which we don't agree with, is that a large animal or a dog caused these wounds. They don't say where, they don't say when, they don't say how. And so
I'm looking
that
up
is not
Yannetti's
a
law
link
firm
so that
right now.
Brian Albert becomes a third-party culprit. Finally, in a way to try to create some type of traction against Brian Albert, they associate him with Brian Higgins because they spent the day together, because Brian Higgins, according to them, was rebuffed because of phone calls at night. All of these general claims with no fact predicate rely on innuendo, surmise, speculation, or just the creation of an inference that does not exist. There is no evidence Brian Albert had any motive whatsoever to harm John O'Keefe. None.
Okay, so Yannetti used to be an assistant district attorney, which is not surprising because that's how some, defense attorneys get their starts.
There is not one witness, there's not one statement that Brian Albert had any animus whatsoever.
Karen Reed has a legal defense fund.
He did not have the motive. He did not have the.
No, they must not be making Mangione money because I don't see anything about the defense fund.
Opportunity, and there is no evidence that he was involved in any way in the alleged collision that happened in the front of his yard that night. Finally, the defense turned to Mr. Higgins.
Boston.
Mr. Higgins was at the Albert address that night. John O'Keefe never went into the Albert address that night. They take very, very select pieces of information, and I would suggest don't tell the whole story. And from that, they want us to speculate a motive. For example, they say that Karen Reed had kissed Mr. Higgins at John's house. That seems to be corroborated in the text messages. According to the text messages, Mr. Higgins essentially says that Miss Reed came up to him and planted a kiss on him. And there's quite a bit of text message exchange that you heard during trial about that interaction. And then at some point, Miss Reed went to Mr. Higgins' house. And so there was some interest, it would appear, from the text messages between the two, mutual. At best, there's a plethora of text messages where Miss Reed is pursuing Mr. Higgins, looking for his time, looking for his intention. In one, she says, I was basically begging him to come over. Do you like me? Come over to my house. There are text messages talking about Mr. Higgins not having enough time for her. So there is a flirtatious relationship between the two of them.
Okay.
What we don't see is that somehow that creates a motive for Mr. Higgins to want to hurt or kill John O'Keefe. The fact that they are texting.
Right. Benji, okay, Brooklyn emailed me a link this morning. I'll take a look now. Benji did not watch. Benji, so I'll just give you some context as far as who Higgins is. In the first trial, the defense, if I remember correctly, I think it was the defense. I think the defense theory as far as Higgins is concerned is that the decedent, in this case, Karen Reed's deceased boyfriend, felt some type of way about some type of exchange between Karen Reed and Higgins, because apparently Higgins was flirting with Karen Reed. It's been a while, so hopefully that's correct. If it's not correct, Brooklyn, correct me.
Together, and later that night, he sends a text message because I think an inference the defense would raise is that he felt like he was ignored or wanted to know what was going on with their relationship. Is not evidence of motive. In all of these text messages, you never see any animosity towards John O'Keefe. Mr. Higgins' text messages are virtually all kind towards John O'Keefe. It's uncomfortable. It's an awkward situation because both of them appear to be deceptive as it relates to John O'Keefe, but there is no vengeance, there is no anger. And so the suggestion that there is a motive
See what Fonny's up to.
text messages to then kill the man is beyond the pale. It's beyond any logical connection that would support third-party culprit. Brian Higgins sent a text message saying to John O'Keefe, asking if he was coming to the home that night, and they then attached the word he lured them to the house. I mean, we do look at this evidence not in a vacuum, but logically and realistically. Not knowing that Karen Reed was not going to come in when they arrived at the house. Is it reasonable? Is it rational? Is it lucid to think that that Mr. Higgins was inviting them both over to the house, not knowing only one of them would get out of the car? Is the suggestion that Mr. Higgins was going to kill both of them?
Sheesh.
Or he was going to kill one of them, so the other one he would then set up for murder so that he wouldn't be able to see her anyways? The absurdity of the relationship between the claim and reality is so great.
I mean, let's quickly get into Yannetti here.
Yes.
Your Honor, the Commonwealth's motion raises three interconnected issues, not just two. I believe that two of those were conflated by the Commonwealth. I'd like to separate them out. The first issue is the introduction or admissibility of evidence relevant to show that somebody else harmed John O'Keefe.
Okay.
The second issue.
When is she actually going to rule?
With the first,
I mean, it has to be before
after
the
the
first.
introduction of such evidence, the defense is allowed to argue that a specific person or persons caused John O'Keefe's death. And then the third issue is whether the police properly investigated this matter in light of the information that they had or information they could have obtained or failed to follow up on to show that somebody else caused John O'Keefe's death. Regarding the first issue, which Mr. Brennan spent a lot of his argument on, There is ample evidence tending to show that somebody else caused John O'Keefe's death. In our opposition, we have cataloged the evidence against each of the potential third-party culprits that we named the last time we were in court. Each one of them had a motive and an opportunity to harm John O'Keefe. The investigators in this case had evidence that pointed to Brian Albert. Brian Albert is a violent man. He was not only a boxer who punched people in the ring, he was also a violent drunk who sucker punched other police officers. Those police officers are on our witness list. He's been investigated by the.
What happened? Dang. Oh no, they lost.
At the time John O'Keefe entered that house, an intoxicated Brian Albert was inside. He had been drinking day and night for hours at a time, and he was liquored up. He testified to that. He was at the hillside when he had his first drink in the afternoon, and he testified under oath he was drinking consistently the entire rest of the day and night. The Commonwealth says that every single person didn't see him in the house. Those same witnesses that the Commonwealth points to, every single one of them also did not see him on the front yard where Mr. Brennan claims that he was at the relevant time period. That day and night, Brian Albert was attached at the hip to his close friend, Brian Higgins. This was the night that after having carried on a flirtation with Ms. Reed while she was dating Mr. O'Keefe, Brian Higgins was confronted with Ms. Reed and Mr. O'Keefe together. In the words of one eyewitness, Ms. Reed and Mr. O'Keefe appeared to be lovey-dovey that night. Higgins had expressed his interest, but it went nowhere. And it went nowhere because prior to January 28th of 2022, Ms. Reed had rebuffed him, essentially ghosted him. She stopped returning his messages. Brian Higgins was liquored up that night as well.
When did she rule?
They're both very large men.
Let me look it up.
The court saw them on the video.
Beverly
Friends who drank the entire day and night.
Noni.
And they were waiting in the house for Mr. O'Keefe to arrive. Mr. O'Keefe ended up dead because he went to Brian Albert's house. After Brian Higgins left, Brian Albert maintained contact with him. At 2:22 in the morning, the two of them were exchanging phone calls to check in with each other just a couple of hours after Mr.
No,
O'Keefe
she did not make a decision.
Mr. O'Keefe had dog bites and or scratches on his arm consistent with a dog or an animal attack. Brian Albert.
I don't know that she made a decision on the third party suspects.
Shepard, who had attacked and injured somebody in the past. It all fits. The Commonwealth utterly failed to investigate Brian Albert as a potential suspect. And I'm sure the court remembers the words in a text message of now ex-trooper Michael Proctor, the lead investigator who's now been fired as a result.
Oh, he had to rub that in.
Investigation. I would point out also that when Mr. O'Keefe was in the house, both Brian Albert and Brian Higgins.
Yeah, because I just looked this up. She deferred on ruling on the third party culprit issue. So she's not made a ruling on that.
According to the testimony. With regard to Michael Proctor's words, he was asked specifically if the homeowner would catch any grief for having a deceased person on his front yard. And Michael.
What's going on with long crime? I keep losing signal.
Was a first responder. He chose to ignore his duty to help somebody in need and instead stayed in his bedroom. And Brian Albert's dog, the family dog, a member of the family for 7 years. Brian Albert got rid of the dog, shipped it to another state, only after it was made known in court that the defense was alleging that the dog had been involved in the attack on John O'Keefe. He suffered those particular wounds from a dog or animal attack. Brian Albert responds to that allegation by essentially divorcing his family from their beloved dog whom they had had for 7 years and certainly considered to be a member of the family. In the aftermath of John O'Keefe's death, Brian Albert went so far as to send that family member to another state. That's enough evidence to point to Brian Albert as a potential third-party culprit in this case.
What's going on with law and crime? I know they just stuck.
She no longer gave him any attention. So we come to January 28th. Brian Higgins sees Ms. Reed in person, but she's not alone. She's instead with Mr. O'Keefe. Ms. Reed and Mr. O'Keefe are affectionate with each other that night, and Higgins is there to see it, as is Brian Albert. There's evidence that Mr. Higgins wants Mr. O'Keefe to come to the Alberts' house that night. In fact, he appears fixated on making sure that Mr. O'Keefe went there. In the waterfall video, Your Honor, you will see that Higgins motions to Mr. O'Keefe when they're leaving. And Higgins even texts him directly after that to make sure that he was coming. Then Higgins goes to the Albert home. John O'Keefe goes inside. Higgins is there waiting for him, with both the motive and now the opportunity to hurt John O'Keefe. Like Brian Albert, there's evidence of his consciousness.
Okay, I'm done. I don't know what these people have going on.
On video, making a phone call. So I suppose the question is, why did he lie about that? The jury in this trial should be entitled to consider the answer to that question. And of course, the police never investigated who he was calling or what he said or who was calling him. Then he goes home and he still stays up. And at 2:22 in the morning, he's speaking by phone with Brian Albert. And he claims that they didn't, but the phone records don't lie. And this notion that these two men are somehow able to butt dial.
But I was about to say that. I was literally about to say that these folks were supposedly butt dialing each other. One was butt dialing while involved in intercourse with the wife. It's weird stuff.
Answer each other.
Yeah,
It's just ridiculous.
he's cracking up over here.
And there's more consciousness of guilt evidence with
Yeah.
when he realizes that investigators might be interested in the contents of his phone to see what evidence might be on it. He demonstrates consciousness.
Let me
of
see
guilt
what
by
Brooklyn
getting rid
emailed
of
me.
his SIM card and the phone.
Where's Gmail?
And how he got rid of it was extraordinary and demonstrates just how badly he wanted to keep that information out of the hands of investigators. He admitted to breaking the SIM card into and making a special trip to a military base to put this tiny object, the size of about a thumbnail, into a large dumpster.
Right.
It wasn't enough to throw it in a waste paper basket or a trash bin outside the local.
And to me, that does not even make sense. For a law enforcement officer, I don't know. I'm gonna stop criticizing people. I'll let it go.
Instead, he went through security at a military base
That
and
doesn't
secretly
make sense.
tossed this tiny broken SIM card into a dumpster.
Right.
He made sure that investigators would never know what's on his phone. And
There's a way that law enforcement can get into that information. I don't know why he thought they would not have access to, his information. Even deleted text messages can be retrieved.
he admitted to that at the first trial. And of course, the investigators in this case, including the lead investigator, former trooper Michael Proctor, never showed any interest in Higgins' phone. Higgins nonetheless accomplished his goal of keeping the contents of the phone out of the hands of the defense in this case. That's powerful evidence of motive, intent, opportunity, and consciousness of guilt of Brian Higgins. As Mr. Brennan acknowledges, all doubt should be resolved in favor of the admission of third-party culprit evidence, linking him to the harm caused to John O'Keefe. And finally, Colin Albert is a potential suspect. He had been in a feud with John O'Keefe. He'd thrown beer cans in his bushes, told him to F off. We have a good faith basis to claim that. This is the same Colin Albert who testified under oath he had never been in a fight in his life, yet there are videos of him clearly desperate to beat up others.
Right.
The same Colin Albert who had scraped up knuckles just a few weeks after John O'Keefe's death. Those knuckles looked consistent.
I know I'll forever associate scraped knuckles with what's the Italian out of New York? I'm drawing a blank. I just had his name. A$AP Rocky's attorney. I'm drawing a blank. I'm sorry.
With an attack on somebody. The photographs that Mr. Brennan references that
I'm
were
drawing a
allegedly
blank.
before that photo had no metadata. We can't confirm when those were taken. Mr. Brennan wants us to just accept.
All right, folks. I have about a
before
minute or
Scrape
two.
Knuckles photo. We don't buy it. We don't think a jury will buy it.
What's the guy's name?
When John O'Keefe was found
What's the
with two
attorney's
black
name?
eyes looking like he had
I
been
forgot.
punched in the face, Colin Abbott was at his uncle's house with both his uncle and Brian Higgins.
Either way, I still think that not the prosecution, the defense needs to focus on. They need to focus on. Why am I drawing a blank all of a sudden? On the lead investigator. Okay, that's where they need to. To me, that's where they have to. I'm not saying they should not thoroughly cross-examine these so-called third-party culprits. What I'm saying is that it is almost inconceivable that all three of these people would have attacked this man at the same time. Right now, they're pointing at three different individuals when they can pretty much point to one person, and that person being the lead investigator, who's very problematic and was fired for the way that he handled this case. All right, so I'm calling it a night. Tomorrow we'll be back. I guess we might get into Fonnie Willis tomorrow. I think that's probably what we do, because with Karen Reed, unless something else happens overnight or we have a decision, there's no point in revisiting Karen Reed unless we want to go back to, why am I drawing a blank on the lead investigator's name? I don't know. Unless we're going back to the lead investigator, we can certainly do that and finish up, or try to finish up, his testimony. I don't know that we get through everything before the second trial actually commences. All right, folks, I am calling it a night. Benji, you have a good time at work. Brooklyn, have a good night. Right, Takapina. There we go. Joe Takapina. I love Wendy Williams, okay? I'm very saddened by the way that things have turned out for her. I'm really sad about that. It's hard to watch. But I don't know. It's in New York, so I suppose under those circumstances, it's not a criminal case, though. Yeah, it's not a criminal case. Because it's not a criminal case, Wendy needs to go with an attorney that's actually well versed in civil suits. So that's my take. All right. Okay, folks, I'm calling it a night. I still have to clean up my kitchen, but I'm calling it a night. I'll see you guys tomorrow, usual time, 8:30 p.m. Eastern time. All right. Have a good night.